Can you leave one of your children out of the will? Yes, you can leave a child out of your will and not make a provision for that family member. However, this will create a very high risk situation of that child bringing a family provision claim, contesting the will. Apart from the stress this causes to the family when they are already grieving your loss, the legal fees are likely to eat away at your estate, such that your beneficiaries will not receive the same amount of benefit they would have had, as the asset pool will then become smaller. Where possible, it is better to leave that child a small amount of money and specify under your will that you have made provision for them during their lifetime, hence why no such significant provision is made in your will. You may then leave the balance equally between the other beneficiaries. This will not guarantee that the child will not make a claim. There is no way to guarantee this. It will just lessen the chances of this happening, especially where there is a small estate. Only your spouse, including your de facto spouse, your children, including stepchildren, and your dependents can bring an application of this nature. In a nutshell, the applicant must demonstrate to the court that adequate provision has not been made from the estate for their proper maintenance and support. In deciding a family provision application, a court must take into account all the competing circumstances, including the applicant's financial position, the size and nature of the deceased estate, the totality of the relationship between the applicant and the deceased, the relationship between the deceased and other persons who might have a claim against the estate, including beneficiaries, and the age, capacities, means of other potential beneficiaries. In some other cases, courts have considered whether or not the deceased owed a moral duty to the applicant to have made adequate provision for proper maintenance and support. So there really is no foolproof way to ensure, if you cut a child out of your will, that you will not end up with a fight on your hands for the executor and the beneficiaries. Give it a lot of thought and make sure you seek legal advice.